We are going to move forward into, for those of you who are not within the public sector, bear with us, as we're going to talk about this thing called legal authorities, which is really important to getting prizes and challenges done within the federal government. And I'm really excited to bring two people up on stage with me and Bob. First of all, my colleague at White House OSTP, Robynn Sturm Steffen. For those of you who don't remember, she was the woman who worked the magic behind the April 2010 event and so many of the advances and tools that we have at our disposal now for using this tool. So we're super excited to hear from Robynn. And I'm also really excited to hear from Jeff Heninger, who's in the Office of the General Counsel at NASA. And one of the reasons that I think Jeff is a fantastic addition to the conversation is that he's lived through the practice and implementation from an agency perspective and comes at this from a perspective of how do we get what we need to get done at our business as opposed to simply starting from the legal authorities. So I think we're going to have an interesting discussion. We're going to start with Robynn.
Hi, good morning. So, this is the most riveting part of the day. I'm sure you've all been waiting for the discussion of legal authorities. If anyone snores, I will look directly at you. But no, seriously, many of you are not lawyers in this room, and that's great because our goal today is to not make you ready to navigate this on your own, but to provide you enough of a framework for how to think about the legal authorities that you can then go and find your general counsel, like Jeff, and be able to work this through with them. So broad strokes, understand the landscape, know what your resources are. I want to start with just 3 big picture framing ideas for you, which is one, everyone this morning has spoke again and again about how critical it is to start with a clear understanding of your mission and of the goal of what you're trying to achieve. The same is true when you think about legal authorities. The legal authority conversation should always, always, always follow the substance. Number 2, there are a number of different legal authorities that your agency might be able to use to be able to do prize competitions. And each one comes with pros and cons. Each authority comes with a certain set of authorities and also a certain set of responsibilities. So when you get to the point where you have a clear idea of what you want to achieve, you're then going to start working through the pros and the cons to be able to pick the legal authority that makes the most sense for you. And then the third is that you don't have to take my word for it. So everything that I'm going to talk about today is actually captured in official memoranda that has been published by the Office of Management and Budget. And so I'm going to refer you to those resources such that you can use them after you depart today. All right, so first, speaking of OMB resources, so in March of 2010, many of you probably have seen this, Tom Khalil talked about it this morning, OMB put out a memo that encouraged all agencies to increase their use of prizes. It also identified a number of authorities from existing statutes, from existing law, that agencies might rely upon in order to do prizes. You see some of these listed on the PowerPoint in front of you, from direct prize authority, grants, cooperative agreements, etc. They're all laid out in the memo. I'm not going to talk about them now because just in a moment you're actually going to hear from Jeff about some real-world case studies of using those particular authorities in practice. In January of 2011, as Tom Khalil mentioned this morning, the President signed the American Competes Reauthorization Act of 2010, which added another arrow to your quiver. So let's be clear, the America Competes Act expands the authority that agencies have to be able to conduct prize competitions. It in no way curtails any of the authorities that we just spoke about and that Jeff's going to speak about in a minute. But I do want to spend a little bit of time to run through and talk about the America Competes Act. So, and another resource that's going to be really valuable to you is a fact sheet in frequently asked questions that was developed by policy and legal staff in OSTP as well as in the Office of Management and Budget and published in August of last year. So this has a 2-page, really quick overview of what are the authorities that come with this law, what are the responsibilities that you have as an agency? I'm going to hit a couple of the highlights here, but speak actually for a very brief period of time in hopes that you'll be able to then ask the questions that are most relevant to you and your agency at the end of our presentations. So a few quick things. One, in terms of scope, 3 important things to know on this front. One is that the Competes Act, the Prize Authority in the Competes Act is actually quite broad in a number of respects. It applies to all federal agencies, defined quite broadly. Number 2, in terms of thinking about when you can use prizes, again, it gives quite broad guidance. So it allows agencies to conduct prize competitions with the potential to stimulate innovation that advances the mission of their agency. Note that advancing the mission of your agency is not something that's specifically tied to technology or to prototyping or to R&D specifically, as some of the other prize authorities are. So this is incredibly broad and can be used for a number of the missions of your agency. And finally, in terms of thinking about scope, it gives agencies a lot of flexibility to pick the prize type that is the best fit to be able to achieve the goal. So it specifically gives examples around participation prizes, exposition prizes, market stimulation prizes, but includes a catch-all to say the agencies can pick the type of competition, the design of the competition that's going to best fit your specific goals and help you achieve your mission. Number 2, money. This is the question that comes up over and over again. So the Act specifically empowers agencies to use appropriated funds to be able to not only give cash awards, but also to be able to design and administer prizes. And those cash awards can be up to $50 million. So the scope is ambitious in terms of the use of federal appropriated funds. The other thing that I'll say is that the Act is clear, and as it's talked about in the fact sheet and the frequently asked questions, the agencies do not need to obtain specific appropriations for the express purpose of running a prize competition. This means that the appropriations that you have may be able to be used for prize competitions. Not all funds are appropriate. You're going to want to work with your General Counsel, but there's 2 kind of rules of thumb that you can think about in terms of using appropriated funds for prize competitions. The first is pretty obvious. Does the goal of my competition fit within the purpose of the appropriation given to me by Congress? If Congress gave you money for educational purposes, then you probably can't use that money for a prize competition that will advance robotics, right? So you need to have a pot of funds that is for the purpose that will be advanced by your prize competition. The second question you'll also want to work with your lawyers on is thinking about whether or not Congress was specific as to the tool that you should use when you're achieving that goal. So Congress will say, here's money for this purpose, and sometimes Congress also tells you specifically, this is how you should achieve that goal. This is how you should work towards that purpose. But often they don't. And when they don't, that's the moment when you can think about the whole set of tools that you have in your toolbox, including prizes as one of them, to be able to use a prize competition to achieve that goal that's been set out for that pot of funds by Congress. So that's money. Moving on to 3, which is collaboration. The quick point that I want to make here is that the Competes Act gives a number of authorities to agencies to be able to collaborate and do the types of multi-sector partnerships that Tom and others have talked about this morning. So specifically, it gives agencies the ability to accept private sector funds without having express or independent gift authority. Number 2, it allows agencies to partner with nonprofits. Specifically, it gives all agencies cooperative agreement authority specifically for the purposes of partnering with the nonprofit for a prize competition under Competes. And third, it specifically gives agencies additional authorities to be able to partner with other agencies. So being able to identify areas of shared mission to be able to design and conduct a prize competition together and to be able to transfer and accept funds for the purposes of that collaboration. On intellectual property, Kristen already talked about this morning, the importance of picking an intellectual property regime based on the goals of your competition, based on an analysis of incentives for potential participants, and also based on your theory of the case about post-prize, how are you going to get that winning solution out into market or into the actual deployment that will meet your goals. The good news is that the America Competes Act does not in any way constrain your use or your choice of intellectual property regimes. What it does say is that if you determine that the agency should obtain an interest in the intellectual property from the winning solution, you need to be very clear in the rules that that's the case and have written consent from the winner before doing that transfer. Finally, on eligibility, just a quick note, I would say one of the limitations from a policy perspective of this particular authority is that it does limit the eligibility to win prizes to US citizens and permanent residents or entities that are incorporated in the United States and have a primary place of business in the US. The last point on this slide is simply to remind you that Competes is just one authority that you have. It's one arrow in your quiver. And it in no way curtails the authorities that were laid out in the OMB memo of 2010 and that Jeff's going to speak about in just a moment. So with that, I'm actually going to turn it over to Jeff to talk about those other authorities, and then we'll both take questions from you across the full range of authorities you have at your disposal.
Thanks, happy to be here. Jeff Heninger with the Office of General Counsel. I actually am legal counsel to NASA's Centennial Challenges Program as well as the Center of Excellence in Collaborative Innovation. So I get a chance to work with Jason and Larry Cooper, who you'll hear from today. Talking specifically now about authorities. And really I want to we want to get to questions. I just want to lay some foundational elements from the authorities that Robynn just covered. When I was in private practice, I spent 10 years in private practice. In private practice, your client comes to you and says, I want to do X. And they come to their lawyer to find out if it's illegal for them to do X. And if it's illegal, they won't do it. And if it is legal, then they can do it. And so they check with you to make sure things aren't illegal for them to do. In the government, if an agency wants to do X, there has to be a specific law that says you can do X. And if there's a specific law that says you can do X, then you can go ahead and do it. So one of the changes I've had to come into as a government lawyer is, are we authorized? Are we authorized to do the thing we want to do? And the second is, are we appropriated to do it? So we can be authorized to walk a pencil down the hall, but if we're not appropriated to walk a pencil down the hall, we can't walk the pencil down the hall. So, authority. Everyone's having issues with this, including me. Threshold considerations. Okay, so talking about authorities. We're going to have different authorities that will provide for different activities with contest or prize elements. We hear a lot of talk about prize competitions. I'll talk also about activities we're doing which include contest or crowdsourcing type elements. Not all authorities are going to be available to all agencies. I think that's something that we're familiar with, but something we need to keep in mind. America Competes is a great authority because it was available to all federal agencies, but it still permits within the realm of certain types of activities and not just do whatever you want that involves contest elements. Consider the agency mission to be involved. That's where this all begins. And consult with General Counsel early. A couple of weeks ago, my daughter is singing in rock band. She's 7. Told her it's time to go to bed. She's in the singing on rock band. She says, Daddy, you're killing my dreams. I feel so often as counsel that I have program folks coming to me saying, I want to do this, and I say, oh, we don't have that authority to do that activity, or at least not in the way you're outlining it. And my program folks looks at me and says, you're killing my dreams. I've already today been called a roadblock to something that we've involved with another agency. Please consult with counsel early, so that as we're ideating, as we're creating our prize design and our prize structure and our approach to this activity, we can do that in a way which permits us to follow the authority that we need to. That authority might have to take us around, and there might actually be activities that a particular agency isn't allowed to do, or we might just have to restructure it. But that's the benefit. I won't kill your dreams if you come and talk to me early. So I really encourage, and I think, I support Centennial Challenges. I'm looking at Larry Cooper. He and I consult often Jason and I consult often when they're looking to do challenges in our agency. It's been a great working relationship, and I'm sure it can work in your agencies as well. We're all here as prize profits, but we have to remember that prizes are a means, they're not an end. We ought to have a mission goal. The mission goal is the end, and hopefully prizes can be the means. Okay, so just talking about some authorities. First, the easiest is the direct authority. NASA has had direct prize authority in its Space Act since 2005. The great thing about COMPETES is COMPETES expanded that direct authority to all federal agencies. Now, it's a particular type of authority. If you read, and DOE and DOD also have direct authorities. Other agencies also might have some type of direct authority specific to that agency. This direct authority, and at least I'll speak for COMPETES and I'll speak for NASA Space Act authority, is specifically states it authorizes the agency to conduct a program to competitively award cash prizes. Allows us to use appropriated funds to provide a prize purse. COMPETES specifically allows us to use appropriated funds to also design and administer a competition. Keep in mind, it's the agency's competition. It's the agency's program to competitively award. The solver owns the solution. U.S. government under COMPETES has the ability to negotiate for a license. I'll hit on this point again, but just remember, if we're getting something for the direct benefit of the United States government, like a license of rights, we also have to look at that through the lens of the Childs Act, which says that if you're going to acquire something for the direct benefit of the United States government, you do so through the procurement process and through the Federal Acquisition Regulation. So we have to consider that. Note, as in everything I'm going to tell you, and then we have to comply with the requirements of that act. Again, in the government, we can only do things if Congress is if there's a specific law that says we can do it. So if we're going to, we have to comply with the requirements to hold it in our left hand and to notify the Federal Register and whatever it might require. An example of this direct authority would be, of course, from my perspective, NASA's Centennial Challenges program, a program to competitively award cash prizes. We did the sample return robot. I got just a little picture of it there. So that's direct authority. Another type of authority that we have, most agencies will have, is to enter into grants and cooperative agreements. Federal Grant and Cooperative Agreement Act, also known as the Childs Act, gives most federal agencies this type of authority. And there are going to be regulations. NASA has a specific set of regulations that governs how it goes about using these grants in certain circumstances. We're talking about now using appropriated funds to provide support or stimulation to accomplish a public purpose. Some capital G good out there is going to be done through the expenditure of these funds. Can't be used to conduct an agency's own prize competition. This is funds that are going to be used by the recipient to support its activity, and the U.S. government's involvement is going to be minimal. We're going to fund, they're going to conduct their competition. Government doesn't own or control the solution, and of course we have to comply with the requirements of the Act. If you're using the Childs Act, some other grant or cooperative agreement authority, or some other regulation, CFR regulation that might apply to your agency. An example from NASA's perspective was we had our folks down at JSC, or Johnson Space Center, who wanted to support the Rice University's business plan competition. Now, this was before we had COMPETES, and what they wanted to do, well, the Space Act Authority allows us to competitively conduct a prize program, but it requires that the solutions be in the form of technology demonstrations or actual applications of technology. Since the result of the Rice University business plan competition was actually a business plan or an idea, we couldn't do it under our Space Act authority. Our authority limited us. So we looked around and said, we'd still like to support this, so we invited them to send us a grant request. And we funded the grant. They took that money. They happened to use the money that we gave them to fund a prize, and they called it the NASA prize. And so a student competitor was able to win the NASA prize. Very successful. Talk to Jeff Davis when you meet him. Ask him more about the successes that we've seen through using grants to support the Rice University Business Plan competition. Again, another use of government funds to support a prize, but totally different from what we would do under direct authority. Another authority. Now, this is an authority which I put under the OGC heavy area. Lots, sort of an amalgamation of authorities, if you want to do something in this area, talk early with OGC because it's going to be very activity and agency specific. But here we're talking about non-monetary support to prize competitions. Authorities or missions in education outreach, partnering, co-sponsorship on a no funds exchange basis. The prize, if there is a monetary prize, is typically in this circumstance provided by the non-U.S. government partner. There's no transfer of appropriated funds between the two parties. Again, the specific authority, whether you're doing it under your education mission and outreach mission, is going to depend on what your agency specifically has the authority to do. Government does not own or control the solution, again. And again, you have to comply with the particular requirements of whatever authority you're relying on to do this no funds exchange type of partnering activity. An example for NASA was really an outreach program that we were conducting with Etsy, which is the online crafts group. And we entered a contest for them to create crafts that told NASA's mission or a part of NASA's story. In that circumstance, it was actually Etsy that funded the prize. And so there was no funds exchanged. We were able to still use prizes to accomplish mission. And then a fourth authority is actually our procurement, our FAR, our contracting authority. We can use a FAR procurement to acquire a solution to an agency problem. The agency has a mission it needs to solve. That problem, that mission can be solved through the procurement process. In this circumstance, we can go out and we can secure a contractor, and the contractor uses contest elements to satisfy the contract and achieve the agency's procurement need. In this circumstance, the government can own and control the solution. Again, if we're going to acquire anything for the benefit of the government, it needs to be through the Childs Act, through the procurement process. So this does allow the government to own or control the solution. So if you have a specific agency solution you're looking to solve, this is a way to utilize prizes, contest elements to achieve that through the procurement process. Have to comply with the requirements of the FAR, including the competition requirements. This is the authority that the Center of Excellence has used in connection with the NASA Tournament Lab and the contract with Harvard and their subcontract with Topcoder, where we were seeking a solution to a number of problems, but mostly we were thinking, computer software solutions. And the contract was solve our problems. The contractor turned around and said, we're going to solve those problems through crowdsourcing, through contests. So we were able to utilize prizes and the benefits. We only paid for a solution, and that's the great thing. We have a contract, we only pay if we get the solution we're actually looking to a problem we don't know how to solve. So those are the major authorities, and certainly things that were in Robynn's slides. A couple of other authorities, again, OGC heavy. One is the necessary expense doctrine. If you read the 2010 OMB memo, you'll see necessary expense doctrine talked about there, which is essentially if you have mission that needs to be achieved, you can do so, or appropriated funds to achieve a mission. If the only way to achieve that mission is through prizes, we can run prizes. But of course, as you can expect, that's OGC heavy. That's OGC specific. And if there's any other specific authority you can use, it's going to trump the necessary expense doctrine. Other transactions authority is authority that certain agencies have, very similar. You can enter into transactions to accomplish agency missions as necessary. If there's more specific authority, other transactions authority is not available to you. There's fiscal issues. Robynn touched on those, which is, of course, we can be authorized to do something. If we're not appropriated to do it, we still won't do it. So we need to be appropriated, and we also have to, and competes allows broad authority with respect to using appropriated dollars. Keep in mind, those dollars still have to be budgeted, they still have to be set out in our operating plan. That might decide if we just, what that suggests is as we're budget planning, we ought to be forward thinking with where are we going to use this prize mechanism so that we can make sure that it's reflected in our budget, it's reflected in our operating plan as necessary. Ownership control of the government, by the government, again, we've got this nice little thing in competes that says the government is free to go and negotiate for a license. That still has to be looked at through the lens of the FAR. NASA hasn't had to deal with that under the Childs Act yet, so I'm interested in how other agencies are going to approach that notion. My expectation is it's still going to have to be FAR compliant. You have to talk with your procurement office. And Robynn talked about the international considerations. Some authorities restrict international involvement. Questions? Happy to have questions. I'll note one thing. When I was in private practice and I'd speak at an event, folks would come up and say, I got a question, and I'd say, happy to answer your question. Okay, I'm getting ready to go into jail. But no. Let's talk hypotheticals. Let's talk up here. I'm not your lawyer. If you give me the same consideration when asking questions here, I appreciate it. Thank you.
Thank you. That is a very well-deserved hand, because I don't know about you, it is hard, but these two did it. They made legal authorities interesting. And I don't know how many of you are from the private sector here, but thank you for thinking through sort of the considerations that your public sector peers have to get through in terms of getting these competitions done. And so I wanted to kick off with one very specific question, which is a question I get a lot, Jeff, in terms of what's your experience been so far with other agencies engaging with the Center of Excellence for Collaborative Innovation, and what that process has looked like from a legal point of view?
I've had a chance to talk with a number of counsel from other agencies. Mostly it is explaining how with the Center of Excellence, particularly when they're utilizing the NASA Tournament Lab to solve an agency-specific problem, they'll come in, we'll put our agreements together, and they'll say, okay, where's the section on American Competes? Because I'm supposed to be doing an American Competes something that I can report. And I said, well, this doesn't involve American Competes, and I explain that procurement authority that I just shared with y'all. This is a procurement, and you actually, the benefit here is you get to own, control the solution on this one. You wouldn't necessarily have that right at the get-go under Competes.
Got it. Does anybody else in the room have questions? Megan.
Hi, thanks. Megan Moynihan from the FDA. So, Kristen, this morning, or a little bit earlier, you were giving us some outlines of steps that we might want to take to make the prize a really good one, and some, things like pulling together a judging panel and maybe bringing inside and outside stakeholders together to brainstorm and help the ideation process. So, one of the questions I had was whether the operating costs of running a prize would be possible to use under the America Competes Act, or is it really just for the prize purse?
How does prize operating funding play under America Competes? Is that part of the America Competes consideration?
So specifically under Competes, the legislation is actually very explicit that it's not just for the prize purse, but you can also use appropriated funds as well as private sector funds for designing and also administering the prize. So thinking about having the ability to use appropriated funds for the full life cycle of the prize when it's appropriate, given an analysis of the specific pool of money, the specific appropriations bill that you're looking at.
There's a question in the back.
I don't think this is on. Okay. You mentioned that agencies can use the cooperative agreement authority, but then you also said that the cooperative agreement funds can't be used to conduct the prize, but perhaps rather to support the prize. And I'm sort of confused about how that would work and how that's actually different from maybe using it as a procurement.
Either for you want to.
I had a hard time hearing, unfortunately.
Can you repeat one more time for us?
Okay, so you mentioned that cooperative agreement funds could be used to conduct a prize, but it couldn't. No, I'm sorry, that you cannot use cooperative agreement funds to conduct a prize, but you could use it to support the prize. So, for example, you gave, you talked about the prize that was conducted with one of the universities. So, an agency used cooperative agreement funds, they gave it to a university, and then the university sent it out as, I believe, a scholarship of some sort. But I don't understand how that's not actually using cooperative agreement funds to conduct the prize itself.
And under the example that I use, it was actually a grant. That one of the characteristics of grants is it's monies that once it goes to the grant recipient, the government, it needs to be used for the grant purpose that was applied for, but the government doesn't have control after that. The government can't, its control is limited by the statute. The notion is we're going to give you grant money, you're going to go and do a good thing with that grant money. So as opposed to running our own program that like our direct authority or Competes would allow us to do, this is one where we're supporting somebody else in running their program.
And then you could use cooperative agreement funds to actually do a program then?
I think this is a question just to help clarify about who is actually doing the work. And I think you're speaking about the fact that when you're choosing these authorities, it's the outside body that received the funds that is actually doing the work to administer the prize, as opposed to the internal agency personnel.
That's correct. And you could do that, I mean, if you had cooperative agreement authority. I'm not sure, I haven't seen a cooperative agreement yet that was used in connection with a prize, and I'd be interested. Cooperative agreements are typically where it's a grant scenario, we're giving money for a good to be done by another organization, but they require some government assistance or help in doing that. But it's still their program that they're running, not the government program. The government is giving dollars, and under cooperative agreement, the government is giving a little bit of assistance as defined in the cooperative agreement.
I would add just one piece there, which is that you may also think about combining authorities. So under the Competes Authority specifically, it does give all agencies cooperative agreement authority to be able to partner with and collaborate with nonprofits when conducting a Competes prize competition. And most agencies, many agencies have independent cooperative agreement authority, but not all. So this just means that you can think about partnership opportunities much more broadly when you're doing something specifically under Competes that you may not have the authority to do independently.
Yeah. And I think we're going to get in this question of how to use nonprofits and private sector support when Raymond starts talking through the role of public-private partnerships, so you can think through those. Eva. Mike in the front, please.
I was curious, perhaps the best way to generalize this question is to ask it in terms of resolving a problem and what potential avenues we could have better exhausted to resolve a problem. So I'm a physician, I get NIH funding. I in fact got NIH funding to study open innovation, and in that proposal, proposed to have $25,000 worth of prize money for a specific process. And the grant was awarded, but the $25,000 was not allowed, with an explanation that NIH could not give me money to give for prizes, that they were authorized to give prizes, but I was not. Now, according to what you just showed, under the grants initiative, the second example that you gave, it would seem to me that that would be incorrect, and our own reading was that it was incorrect. We didn't get anywhere with that. We didn't get the $25,000. We sought it elsewhere. What should I have been aware of in terms of other opportunities for outreach to try to resolve that question?
So from a big picture perspective, I think neither Jeff nor I are in a position to make a determination on the particular legal question.
Right, and that's why I'm asking about process.
Because it will depend on the specific facts around the appropriations and around applicable regulations that are often agency specific. But what I would say is that you have a number of resources that are available to you. OMB and OSDP put out the guidance in August of 2011 specifically out of a desire to be able to help lower barriers to understanding a very new legal framework. So it may take some time to be able to expose the full breadth of all of the actors that are important to the life cycle of a prize competition, to all of the authorities and flexibilities and also responsibilities that have come into play over the last 2 years. I would also say, and I don't want to speak too much for Jeff, but one of the reasons that we, from a policy perspective, are so excited about the Center of Excellence for Collaborative Innovation is that they're really thinking about support for prizes in the public sector as something that's not only needed for program managers, but for the entire team of people at an agency that need to collaborate together in order to be able to do something that they've never done before. And a key part of that team is going to be the attorneys, and having Jeff be part of that team at the Center of Excellence is going to be important for speaking to and kind of walking through things with their counterpart at agencies that may be more new to using prize competitions.
And we've been doing that as part of the center. I've had, as I shared, councils calling and speaking to me, and we walk through some of these things and we see some of the roadblocks that they have from their agency. Sometimes we're able to share new ways of looking at things or just new approaches. So.
Okay, I'm going to take a question in the back.
Yes, hi, I'm Natasha Caloris. I'm with the Health Resources and Services Administration. My question is more about public education in the health sphere. So if we were to issue a challenge about developing, Sorry, I don't know if I'm too close or what's happening. Okay, that's better. We're interested in knowing whether challenges have been issued that are more of a two-part challenge. So one would not only be the innovative, creative development of the public education tool, but then secondly, the actual dissemination. So it's one thing to really develop the cutting-edge educational tool, but it's another thing really to disseminate that widely within systems of care. And that's really, I think, where there's been a barrier for understanding. If we develop this great thing, how are we actually using it? Are there examples of those kinds of two-phased processes where a challenge can be addressed not only in the development of the tool, but also in the outreach and dissemination?
Oh, no, you can talk about that. I was going to say the one thing that I think of when you note that, the one legal consideration is simply you're obviously talking about something where you want to, it sounds like you would like the government to be able to control the solution. So when putting together the thoughts on the authority and how to pursue that, keeping in mind maybe using a procurement approach might be useful in that, because then you can control how it gets disseminated.
So two thoughts for you on that specific question. In terms of thinking about, I think from a design perspective, it can often be very powerful to think about milestones in your prize design, and so I think that's a great question. From a legal perspective, this has already been fleshed out actually within the Department of Health and Human Services. So you might look at some of the most recent competitions that actually have come out of the I2, the Invest in Innovation program, because they've been experimenting with how to use the existing legal authorities to be able to do that type of milestone-based prizes. The other one that I would mention, which was talked about earlier this morning, is the new CMS competition that's been launched in collaboration with the Center of Excellence for Collaborative Innovation, where they're actually going to be building open source software through a series of multiple, over 50 mini competitions to be able to achieve the end goal. So I think there's some really interesting things that are happening there that you might be able to look to as a model.
And one other thing I would add on that, we talked about during the planning stage of design, thinking through stages. One of the competitions that will be talked about on an afternoon panel is the Mozilla Ignite competition, and I encourage you to look at that because it looks at idea generation from one community of solvers and then implementation and prototyping from potentially another, and so that allows you to reach out to more than one audience and skill set. Yep.
Hi, I'm David Vidovsky with the Environmental Protection Agency, and I have a question about kind of the other end of the cycle, which has to do with the legacy portion or the reinforcement stage, where you're leveraging and amplifying the value of the innovations that come out of the competition. And kind of a two-part question. One is, for the awardee, once they've been awarded the prize, and to bring that into the market and into deployment, additional capitalization may be required for technology refinement, integrating into existing systems, or gearing up the manufacturing. Does America Competes allow us to use resources to support that, or is that an instance where you start to cobble together other kinds of authority to reinforce and amplify the innovation? And the second part of the question is, in addition to the winner, there's the kind of the also-ran, the second place winner through 10th or nth place that also may present very valuable innovative solutions that may not be kind of the first past the post. What kind of mechanism do we have from the federal perspective to support amplification of that kind of innovation for those who may not be the award winners but may be valuable to the purpose of the prize?
Well, one of the things I love about his question is that both of those questions are focusing on legacy planning, which is, if you don't remember, one of my very favorite places for you to start. So do you two have thoughts on that question?
So the one thing I would say is that on the latter question, to start with that first, it's fundamentally about kind of how much flexibility you have in designing the prize competition. And the thing that you'll note as you read through the America Competes Act is that it's actually quite short. And so it's very specific about a couple things in terms of eligibility, et cetera. But on most things, it's actually silent, which gives the agency a ton of flexibility to be able to take that framework and really have the design of the competition follow the goals and the objectives that you're trying to achieve as an agency. So that's terrific. In terms of thinking about the use of appropriated funds for the legacy pieces, I think the conversation you'll want to have is taking a look at the specifics of what it is that you want to achieve, understanding the ones that fall naturally under administering the competition, because obviously there's a number of things that happen post-award that are still part of administering the competition. But also thinking about the many of the things that would fall into that category are already going to fall under additional existing authorities. And so I think that thinking about how you can use prizes as a tool in the toolbox that is not the right tool for every piece of that, but should be used in a very integrated way in a comprehensive approach to innovation is exactly the right way to go. And that will mean often combining a number of different legal authorities to be able to do the full end-to-end approach.
And Bob, I think this is exactly what you were hitting on in terms of that this is part of the broader life cycle.
Yes, I did want to mention that we just now had one prize where we actually made 2 awards on it. They actually had 3 solutions that came in, but the program manager on the project decided that in order to reduce his risk down the road, he wanted to take both the prototypes. So he made 2 awards, and he's now going, and we got a license to practice, so he's now taking two completely different processes forward so that he will be successful in his overall program.
Okay.
Wanted to point out your first question. Once they win, the solution owners win, under competes, they own that technology, they own the intellectual property, they can do whatever they wish with that intellectual property. They can go to market, they can go seeking other grants or other support. One thing you might see is that individual come back to the agency and maybe enter or participate in a small business program, SBIR program for developing now that technology, and might enter into a contract with the government to show a demonstration now of the technology. So as Robynn sort of points out, there's going to be other tools that might help that, but as my expectation in most circumstances you're in, the prize is done, the prize is awarded, and the prize tool is done working. It's achieved its end. As far as those who didn't win, they continue to own their intellectual property. Whatever innovations they've made, they might not have won, but they can still take those innovations to market, and they might be able to then go enter into a SBIR contract or some kind of technology demonstration with the same agency or another to continue to develop.
I just wanted to jump in on that one point because we touched on intellectual property a number of times as we've talked about. So I think it's worth noting that actually OMB's General Counsel has read the intellectual property provision of the Competes Act to be more flexible and more broad than what Jeff just articulated. And this, I think, shows the necessary element of working with your General Counsel and using the resources that are available to you as you think through the specifics of your agency and your regulations. But specifically in terms of seeing what's in question 15 of the OMB FAQ in interpreting the specific provisions of intellectual property in competes, OMB interprets it to allow the agency to either allow the winner to take to own the intellectual property, as Jeff mentioned, but it also offers the option of the agency also obtaining an interest in that intellectual property. What it does note, the interpretation that OMB has provided, is that if you are going to take an interest in the intellectual property of the winning innovation, you need to have written consent from the winner. Now that may take, as they note in this frequently asked questions, that may simply take the form of them consenting to all of the clearly articulated rules of the competition up front, but it is really important to take seriously the responsibility to be very clear about what the intellectual property regime is, who will own the winning solution, such that competitors can take a look at that intellectual property regime and decide to opt in or not, if they think that it's an appropriate fit for their own incentives vis-a-vis that IP. So I just wanted to note that it's worth taking a look at Section 15 as you talk to your own general counsels about interpreting the flexibility you have vis-a-vis IP regimes under competes.
So last question. I told you that legal authorities was going to be exciting. Last one.
Hi, Chad Nelson, Food and Drug Administration. I just had a question about the use of funds and where the funds actually sit while the prize is going on. So given that many agencies are on a yearly budget cycle as far as appropriated funds, and obviously we're in a use it or lose situation if we don't use appropriated funds within within the fiscal year, how do we set aside the funds for the prize that may be awarded a year or 2 years from now, or sometime in the future? And I think you talked about a little bit about a prize purse, and also if we're working with industry, how do they essentially add to that purse so that we can expand the prize or enlarge the prize? Thank you.
Yeah, your second question is really more of an OCFO of Office of Financial, your finance office question as to how they're going to take in the money. At NASA, once that money is obligated, meaning the prize has been announced, then it retains a no-year character for purposes of waiting until that prize is then awarded a couple of years later. So long as you're obligating within your appropriation time, then you're able to pay out whenever the prize is awarded.
Anything else on that one? Okay, thank you for your question. So we're going to transition now away from legal authorities, though you may think of additional questions as we wrap up this session, so keep those in your pocket, into a question of the role of public-private partnerships in pulling these off. And you've heard reference to this several times already today. But I think it's really important that we pause to think about the different variations that those partnerships might take, because there's actually a very broad spectrum. And one of the things that I'm excited to share with you is that through Harvard Business School, there has been a new study released, a new paper released about the role of public-private partnerships. And you're going to hear from one of those researchers at the Harvard Beckman Center, Raymond Tong, to tell you about the interviews he's done with administrators of competitions, both inside and outside of government, to understand how these play a role. And I really want you to pause and think about how this might help you get your mission accomplished, because I think that this has been one of the ways we've seen the more robust government public sector competitions come to pass. And we will make sure to distribute a link to this paper after today so that all of you can dig in more detail.